Everyone, welcome back to the final day of Conference 4.5 on Employment Law Essentials for Entrepreneurs. We hope you all had a restful evening and are ready for another day of insightful discussions and valuable learning. It was an incredible journey exploring the topic the last 2 days, and I believe that a lot of you did network a lot in the chat box too throughout the session. So, no issues with that. Let's continue our discussion today and hope everybody enjoys it. We have our panelists, Dr. Kazushi Yamamoto, an esteemed professor of law at Tashkent State University of Law, specializing in international and constitutional law. Previously affiliated with Shizuoka University, Japan, Dr. Yamamoto brings a wealth of academic experience and a strong foundation in cross-border legal studies. Holding advanced degrees including LLB, LLM, and doctorate candidacies, his work reflects a deep commitment to global legal education and scholarly exchange. Dr. Yamamoto's expertise and research continue to shape discourse in international legal systems, making him a valuable voice in comparative constitutional law and legal theory. Our next speaker for today is Dr. Nimisha Kaul, an advocate and seasoned professional in strategy and transactions. With experience at top firms like E&Y and JP Morgan, she brings deep expertise in valuation modeling, economic advisory, and transaction strategy. Dr. Kaul holds a PhD and an MBA from the NYU Stern School of Business, combining strong academic grounding with global business insights. Her unique blend of legal understanding, financial acumen, and strategic thinking makes her a valuable voice in conversations at the intersection of law, business, and economics. Moving on, we also have Mr. Rohitash Sinha, a partner of labor and employment at King Stubb and Kasiva, and a seasoned expert in employment laws and workforce strategy. With extensive experience advising clients across industries, Rohitash specializes in regulatory compliances, HR policy formulation, trade union matters, and employment transitions, such as secondments, retrenchments, and downsizing. His practical, solution driven approach has made him a trusted advisor to leading businesses navigating India's complex labor landscape. In addition to the advisory role, Mr. Sinha is an accomplished litigator representing clients before various courts and tribunals. His commitment to delivering holistic legal support makes him a key voice in shaping the future of employment law in India and beyond. Next up, we have Ms. Swastika Goswami, a corporate counsel for Asia Pacific region at Rimini Street and a dynamic force in business strategy and stakeholder engagement. With a strong foundation in management and a passion for fostering innovation, Ms. Goswami has made significant contributions across entrepreneurial, consulting, and corporate platforms. Her expertise spans business development, strategic partnerships, and corporate communication, with a focus on aligning organizational goals with the meaningful outreach. Known for her clarity of purpose and collaborative spirit, she brings valuable insights into building impactful alliances and empowering youth-led ventures in today's evolving business landscape. Moving on, last but not the least, we welcome Ms. Maria Kedaka, Managing Director of My Way Homes Limited, a real estate company based in Zambia and a dedicated peace-building advocate. Maria is a senior fellow and a subject matter expert on youth with a strong commitment to youth empowerment, interfaith dialogue, and intercultural understanding. She holds a Bachelor of Arts with Education and is currently in a final year of pursuing a Bachelor's of Law degree. With a passion for inclusive development and social cohesion, Ms. Daka actively bridges the worlds of education, law, and community leadership. Her work continues to inspire young people to become agents of peace, dialogue, and meaningful change in their communities. We are grateful for all of your presence and eagerly anticipate your valuable insights and contributions to today's conference session. We would also like to inform all the audience that the HR team is conducting polls in the chat box throughout the session, and we encourage active participation from all of you. Now, before commencing our session for today and inviting our first speaker on the panel, I would like to request all participants to kindly switch on your webcams and keep them on throughout the session to ensure that you are certified and you also have a two-way interaction with all of our panelists, which is the most important part of any event, right? Until and unless we are having a two-way interaction, I don't think a one-sided relationship is going to last very long, is it? Okay. Yasin, Aditya Gupta, Lakshay, Pranvi. I can still see some webcams off. So please, participants, do kindly cooperate. And I believe you have the wonderful opportunity to interact and network with a lot of panelists from various countries and from various industries too. So please utilize the option. Thank you. Now moving ahead, I would like to invite our first speaker for today, Dr. Kazushi Yamamoto from Tashkent State University of Law, to commence his speech and share his insights with all of us.
Hello, good evening. Good evening. Can you hear me? Yes. I'm very honored and actually here in Japan, 10:30. So I'm hard say try my best to be waking up. and, okay, I'm very much privileged to have this opportunity, through the CEO at SK A&G. So thank you very much for giving me the opportunity, the head of the association, and we had a talk a little bit beforehand, and I think it was fascinating talk between the CEO, kindly, and me. Thank you very much for giving me this opportunity. So I am the precisely talking about my several status. One of that honorary distinguished University Professor of Law, Tashkent State University of Law. And the president CEO kindly talked about my affiliation before in Japan. He talked about me as of Shizuoka University, but mainly as an institution, I have been, having a relationship with Nagoya University, Graduate School of Law. From the point of view of a school in the society, I belong to the University of Tokyo side, and University of Tokyo side, and globally, it's University of Oxford, and also John F. Kennedy's Institute of Georgetown University in Washington, D.C. So I'm activating myself, to be very global level, and at this time again, through the introduction of a honorable institution of a CEO, I'm privileged to have a collaboration all of with you. Some of you are in the business side, very few of you in the investment side, and some of you at the professionalist side, say the practitioner in the law or consultancy, in any other field, and somebody professor like me. So I want to talk about theme, the labor law issue, and I think it's about the starting the business and also a little bit about the investment. So there are lots of things to talk about it. The very technically, the issue, it's like the compliance and risk management or the employees, rights, how to protect, and at the same time, the kind of efficiency of the making profit at the same time, or clearly stating the workplace laws or conditions, say the very much inside of the law of the company, or something like the in conducting the employment, the contract itself is a very important because the relationship with the management side and the employees are the very key to run the company itself, and it's very important to talk about it from the point of view of human resources. I got it because there are many aspects of to make the company great. There are so many aspects, from the point of view, especially I'm an investor, some of the portfolio of my availability, to do the investment, there are so many the factors to think about, to make it the greater, the bigger. But from my understanding, objectively, like the investment to the company, and at the same time, investment into ourselves, the most valuable the object or subject is both human. So this topic, the labor issue is the one of the keys to talk about the business startup or making the good things through the activity of the company to the society or to the global society to be evolved via activities. So this is very, very, core issues to talk about. So if we talk about very the precisely the case about the labor law, maybe we need to raise up the cases studies and the successful stories, where the company has been growing up, say the England, the UK, and the United States, Japan, China, India, for instance, blah blah blah. But I would like to talk about today is about do you know the stories about the theory, the Taylor's management system that was, raised up in the United States, especially the late 20th century and, sorry, 19th century to 20th century. It's pretty much, objective the way of the management style that was pretty much, raised in the US. Once it came to be destroyed, but again, 1970 or something, it raised up to the management theory. So it is like, from the point of view of human investment, the resources, it's very objective. Looking at the company outside, say, analytically, some of the numbers, and the humans come to be the number objective to be how they counted. The number, I mean how can I say, the numbers of effectiveness of a company, and the human resource can be the object to be analyzed to get the company the globe, right? But I think it's very, the wrong to think about that way, from the even point of view of the management side to have the company globe, because after all, we are in an environment, society, in the global world, not to be the object or not to be the subject. Subject is like the management side or investment side to have the company objectively to be global. And not like that way, we are, involved in the society to be, how can I say, the combined with everything. So those kind of a view, can be seen in the global the trends like the sustainability or SDGs a little bit. But anyway, labor issues can be or should be, viewed from that way. If you take the example, the management philosophy, say, the very successful guy in, say, the example in Japan, and Matsushita Konosuke or the Inamori Kazuo, those philosophical, the thinking is very, very popular. And I think it's, their philosophy contains a lot of the good things to have the thing, everything successful in a good way, to be happy, even for the management people. That is, when we look at the company, the people, personnel should be viewed in the very central, the core point of view, not to look at the people working there, objective, the kind of a resource, the objective resource, but say we are the partner, the employees and the management side, all the way, same the fellow in the one company. Company comes from the term, the Latin, com and pani. So we have the food together, right? So from those point of view of taking the company itself, from the history, maybe we can have the very right view between if we dare to use the concept, employee and the management, we are the fellow together to have the company grow together. So I think, this kind of, the philosophy would be the very central. And we can talk about the very details of a very technical issue of labor things, from the point of view of law, say the court decisions and proceedings, in an England way, or the continental way. We can find some legislature, the proceedings, say in Japan, Germany, France. Well, anyway, we talk about it in a very specific, the special way. But at the very point of view of how to look at the company itself, or why we are having a company for the humans being for the 22nd century, our enterprise to make the world better, and the way make the better world together. why we have the company. I think it's very important to look at the way. Thank you very much.
Thank you for your amazing speech, Dr. Yamamoto. Uh,
Yeah, thank you very much.
Sure. I would like to request you to share your email ID in the chat box. Since we have a time constraint, if any of the audience has any queries, they can directly reach out to you. Thank you a lot.
You mean you are kindly asking me to share my email address to everybody?
Sure. In the chat boxes.
I got it. Thank you very much for
Sure.
doing so.
Now, moving ahead, I would like to invite Dr. Nimisha Kaul to share her insights with all of us.
Hello everyone. So I would like to present my screen. That is possible. The rights are there.
Yeah, it is. Fourth button from the right.
I got it.
Okay, sure.
So is my PPT visible? Is the screen visible?
Now is your screen is visible.
All right. Okay. Hello, everyone. So thank you so much for giving me this opportunity. Firstly, I would like to make some clarifications. I did not work with ENY. I have a history to work with KPMG India. And I have done my PhD, recently completed my PhD from Indraprasth University, Delhi University. It's a state government university, not from NYU. So there must be some confusion with respect to the details. So I just wanted to clarify these things firstly. Now, my PhD is specifically in relation to labor laws, and I play in between academics and the practical world, basically, because that is what I enjoy the most. So I love to do research as an academician, but I also enjoy to apply it on the practical aspect. And while pursuing my PhD, while my time in the KPMG, though I always see that there are compliances issues, legal advisory issue, but today, keeping those aside, because I believe these are general issues which most of the people discuss, I want to focus on a very different issue. The issue of not having right kind of contracts and internal policies in the organizations, which is an issue I see very regularly with organization. Now, you all have heard about this quote that the best time to plant a tree was 20 years ago, and the second best time is now. And you know what? This kind of perfectly applies to all the kind of legal infrastructure in a startup, because when you are starting your startup, starting your organization, so we always focus on the other part of, the technical part, and we forget about the legal foundations. And when those are ignored, it can actually lead to very huge risk. And if you are doing it right from the beginning, when you are building your organization, you are saving yourself up money, and it kind of helps to build a good culture in your organization. Because it is very necessary to understand that our internal policy and contracts, both of these things are there to help and build a certain kind of basis to the organization and create clarity and some kind of credibility to the organization. Now, I'm specifically going to focus on my research, on my topic for today, on contracts and internal policy. So understand contracts as something which you are having, say, with employees and maybe with your clients. These kind of, basically, you are trying to highlight in the contracts that who will do what would be the timeline to doing it, what would happen if something does not do. You are clearly defining these things, writing them down, getting them signed, maybe putting a stamp paper to it, so that if there is a confusion in the future, you always have the contract to go back to. Otherwise, this can affect the efficiency of your organization, and this happens all the time, that some kind of confusion and miscommunication happens, and the organization's focus suddenly, from focusing on the technical part or going ahead and developing the organization, it completely shifts to solving the legal dispute. And when we come to internal policy, basically you are telling your employees, the people who are working under you, and how you are supposed to behave, what are the guidelines, what are your expectations. You all must have heard about POSH. Similarly, there is leave policy. At this point of time, there are remote working policies. All these policies are there, and you are supposed to have that from the very beginning. That is what is advised, coming from a lawyer point of view. Now what happens when you do not have a contract? Okay, so lot of misunderstandings is there, and there is no reference point. Imagine that I tell someone, okay, you know what, I want you to make this one app for me. Okay, and this person says okay, and there is some informal conversation which happens, some money is agreed upon, and the work begins. Now this person is not delivering you the work at the date which you decided. So this person says, no, that date was decided. You say, no, this date was decided. Then maybe the scope of work increases. And when this confusion happen, your app gets completely sidelined and you get lost in that communication banter. To avoid these kind of situations, contracts are very, very necessary. Similarly, if you have an employee and you are not writing it down, making it clear in the contract that what, you cannot disclose this information to outside public, you cannot put this on social media, and they are going around and doing it, tomorrow you cannot stop them by saying, what, you should not have done it, because you did not sign a good contract for them defining all the things. So this is the reason that signing contracts from the very beginning is very important. Now I want to share a few case studies with you. One is with respect to the co-founder conflict. Imagine you and your friend, you both decide to start an organization, okay? But later on, say after a year or two, your friend decided that you want to exit. Now in friendship, things are informal. So you did not sign a contract. At that point of time, the person who is exiting is asking a share in equity, is saying that, what, the intellectual property, the product which is developed, maybe like some software, is mine. Now there is problem, now there is confusion, and what happens, the business which was running smoothly, that gets stalled, and the focus is on solving this dispute. If this would have been talked about from the very beginning when the organization started, it would have made things very, very easy, that what would happen if either of the founder decides to leave. Similarly, I'm pretty sure that you all have heard about POSH policies, prevention of sexual harassment at workplace. Even if you are an organization who has less than 10 employees and you don't need to form an internal complaint committee, still you should have a POSH policy which completely clearly writes that in case a woman is facing any kind of harassment, who should she approach to, what is the local complaint committee which is there. Either ways, you have more than 10 employees, less than 10 employees, this policy is very important. And see, you need to understand that what happens in today's time, social media is very relevant. Okay, if you don't have these policies in place, people actually go about in social media, on LinkedIn. I've personally witnessed interns going and writing very bad things about their experiences, organizations. So these policies are very important to safeguard the name of your organization, the kind of brand that you are building, because if you will not safeguard it right now, it will lead to negative publicity, which will lead a bad name in the in the industry setup, which will completely affect the work that you are doing. So you are supposed to have these kind of policies in place. Also, I have always seen that employers constantly complain about this one thing, that what, we are training the employees, but they keep on leaving, and that is what we keep on doing all the time, hiring, leaving, taking a lot of time. When these policies are there, code of conduct, POSH policies, specific contracts are there, employees wish to stay, especially the Gen Zs, which is the current organization which is coming at this point of time. When they are there, I have seen that they are very much interested in a good environment, in a good working culture. These internal policies are defining the working culture of your organization, and this is the reason that special focus should be put, because in business it is much more than just the technical aspect that you are developing. The people you have, if they are staying, if they like the culture, it will add on to your business, because you are not constantly training the people, you are building them up. So they would also like to say, so these are small nuances and reasons that you must focus on this aspect as well, the contract part as well as the internal policies part. Similarly, you hire a freelancer, the example which I just gave, and you have not written what is the scope of payment, and there are delivery issues. Again, your work, which was important, gets delayed, and you get, busy in all of these things. Now, Now, you are someone who is just starting. This is a small checklist that I made, that basically you can have like at least these things you should have, like a founders agreement, a basic employment contract, NDA, non-disclosure agreement, that what are the things that the employee or the client or the freelancer can in no way disclose. Maybe tomorrow the freelancer work gets over or the employees leave, still you are supposed to write in the NDA that it supersedes that, and that you cannot go ahead and disclose it even later on, even when the contract is over. Similarly, if you are having some third party contract, you are taking some goods or services with some business, so there are vendor agreements. These kind of agreements must be there with all the organization. You must have a specific format ready with you with respect to your requirements, and you should get these drafted from your lawyers. It is very important. Similar goes for POSH and code of conduct. I already talked about. Now, leave policies are important. Remember that your employee deserves, it's a right of the employee. So these clarity, if you will give now, that they can have leave at this point of time. And how do you expect remote work? Okay, you are saying that remote work is allowed, but if there's a policy in place that what, okay, we expect the employees to come for 3 days, and then 2 days they can do, and there are a lot of meetings happen, you can also mention there that what do you expect from them, that if there is a meeting happening, you expect them to switch on camera, sit in a place where they can be easily talked to. You can actually put all of these things in the policy, and one, there will be not any discrimination. Everyone would know what is expected out of everyone. And please remember to not keep these policies like just you have made them and now they are like having dust in a box. No, you are supposed to bring this in conversation. You're supposed to make your employees aware about it, and you are supposed to have some awareness, like maybe every 6 months or every 1 year HR should go ahead and talk about it. Similarly, what kind of IT policy you have, what are your expectations with respect to someone using, say, their personal email ID on the on the laptop of the organization, or the personal computer of the organization, and do you allow, say, a public internet to be used or not, and how do you secure the data, especially if you are a kind of organization which is collecting data of the customers, then how do you keep it secure? Also, this is a legal compliance with the DPDP Act. So these are the benefits which I have kind of already discussed, that consistency is there and you have strong organizational culture. And of course, you pay your lawyer right now a little, or maybe you pay a lot later. That depends on you. Remember that a contract will give clarity, and the right policy will lay down the basis of the right kind of culture in your organization. And this would be a legal action plan, say, not written down everywhere, just something I have come up with my experience, that in first 6 months at least you should have these basic things like the fund owners agreement, NDA, basic employment contract, POSH policy, agreement format with your client, and then you build it up in the next 6 to 12 months. Make sure that you have remote work policy, data protection. It is very important in current times. I would like to insist on this, to must have a social media policy, because these days every other person is a blogger and they put things, sometimes important, necessary things, sensitive information in social media. So you must put down very clearly that you cannot share, say, insights of a meeting, some important document, picture, even a picture from the meeting going on. These things must be put down in today's world of social media, because you must be very active to guard your image in the community. And thank you so much. These are my details, and you can get in touch if you wish to. And I'm available on LinkedIn as well. Thank you so much.
Sure. That was a great speech, Dr. Paul, and a presentation too. I'm sorry for the mistakes in intro. I guess our team might have made a bit of mistakes. No issue. Apologies.
I think it was a mistake from my end also. I was asked in the email to give an introduction, but I forgot to send. And now I was thinking, so maybe they found something on the internet or something. It's okay, not a problem at all. But I just thought I should clarify it, because I don't want to on a platform.
Sure.
Anyway, thank you so much. Thank you.
I would like to request you to just share your email ID in the chat box, so that if anyone has any queries, they can directly reach out. Sure. So I'd like to firstly thank Dr. Paul for her amazing presentation. And as I was watching, the co-founder conflict is obviously the most common one that we lawyers come across whenever we are representing startups in NCLT or NCLAT. So yeah, that was quite a important thing that she elaborated on. Now moving ahead, I would like to invite Mr. Rohitash Sinha to come in and share his insights with all of us.
Thank you for having me on board. And thank you, Nimisha. You've made my work with regard to policy formulation quite easy as to the kind of presentation that you gave. Thank you so much,
sir. I am happy to know. All the best.
No, absolutely. Good evening, everyone. And thank you so much for having us on board and sharing these ideas across the board. Before I start my presentation, I would really want everyone here who's present, because when I delve into the presentation, I would like to know certain things. Do we understand what data protection is? I mean, by show of hands, if we can just have yes, no on the chat box also. Thank you. So I will take that as a yes, that we understand what data protection is. Now I will play the devil's advocate as my previous speaker, Nimisha, was doing. Do we all have policies with regard to data protection in line with the new Data Protection Act? I'm pretty assured Swastika would definitely have one. What about the others? Okay, going a step further. Yes, that's good to know that there are a few. Great. Now, are those policies taking into consideration all of these aspects, your data protection policies, as to what you need to do for employees or an employment related perspective? Thank you so much. That is where my today's presentation is going to delve into. For a long time, since the passing of the DPDP Act, yes, Swastika, I'm pretty assured that there would be certain parts to it. For a long time, our policies for data protection, confidentiality, data sharing, everything is something which the IT department does. The human resource, employment lawyers are all, partakers to something which, is, they are not really the stakeholders in it. But the idea is, or the currency basically should be that, you need to be a part of it. You need to have a stake in it. Right. So my today's presentation dwells into aspects which need to be taken into consideration for data protection. So I'll start my from an employment and employee related perspective. So I'll just start my presentation. How do I go about starting it? Because I've clicked on the three. Oh, sorry. This one. Sorry. Pardon.
The arrow which is...
sorry. Yeah, pardon. Is my PPT visible?
Yeah, it is, Dr. Sinha.
Is it visible now?
Yeah, obviously it is visible.
Yeah. Okay. So let us understand the object of the Data Protection Act in terms of, and the data protection principles in terms of the employees and their rights. Now, why do we need data protection, or why do we need to understand? So, the importance of data protection in terms of employment or employee-related rights. The first and the foremost angle which we need to look into is with regard to the transparency provision, which has been primarily laid down in the Data Protection Act. Correct? The transparency aspect is the most important aspect which needs to be satisfied. Hence, from the point of view of an employee needs to know why you are taking his data, what is the purpose of the data, what will it be utilized for. So let's say, for example, if you're going to take a blood group of an employee, you need to tell him why you're taking it. It may be for accidental insurance, it may be for such. And what are you going to do with that data? So it can be used legally for entering into records. It can be used legally, for financial purposes, for checking tax records. So these are the things which need to be taken into consideration. Two, you need to take into consideration the fact that the law is in relation to protecting the rights of the employees. So a lot of back channeling needs to go into thinking that if we are going to take extra documents or if we're going to take extra information, so what? That mindset from a perspective needs to change. And that mindset from a perspective even needs to change in the data protection clauses in the policy that you draft within your employment agreements. As to why we are collecting the information, the reason now needs to be given. And a more specific reason needs to be given. Last but not the least, which I kind of always put across, is that data protection is a component of privacy. And privacy of personal data is data protection. Correct? So now what the courts have done is they have almost, I won't say certainly to the 100% extent, but they have almost extended all of these aspects of data protection to a right which is available to you as a constitutional right. Correct? Now we come to the second part, and which is basically that what is employee data and what is consent. Now let us understand what consent basically means in terms of a data protection. Consent basically means the information that you give out or the information that an employee gives out as a requirement or as a position that the company needs to take forth from the point of view or from the perspective as to why it is being taken. And for that, he provides his consent as a yes or a no. Hence, it is important to realize that without an employee's consent, you cannot collect any information. Correct? So let's say, for example, you behind the employee's back collect or connect some important information through maybe a medical record or maybe through some other thing. You're not allowed to do so. All the information now needs an employee consent. Hence, all of the clauses in privacy policies, in documents which contain the language that the company may from time to time, without allotting any reason, for any reason, may collect such information or may connect any information from an employee, and the employee is bound to give the same, may have to go certain change now. Correct? Because from time to time, you may have to take his permission, you may have to take his consent and provide him a reason as to what it is being there. Now, all of us were, pretty confident and were pretty happy before the DPDP regime, kind of kicked in, that whatever data I'm collecting, or in case I do need an employee consent, that consent is only for sensitive and personal data, which is your PAN, TAN, Aadhaar, correct, blood group, medical records, all of those things. Now, what the new act does, it strikes away any fear with regard to sensitive personal data or non-sensitive personal data. In fact, the idea now is that everything is sensitive personal data by itself. Hence, it is important to note that you need to understand that before collecting any information, which is not generic in nature, like his name, like maybe something which is publicly available document, everything else is private data, including his address, including information which we may have willingly given to you. Correct? And what also needs to be taken into consideration is with regard to the existing employees. Now, a lot of people in companies have come back to me, a lot of people in entities have come back to me saying, we have about 5,000, 10,000, 15,000 employees. Are we now expected to go back to the regime, to go back to the employees and tell them that please submit your data once again? And if yes, how? If no, what are the other implications we can do? So the implication is to be done contractually, which is to state that please note or please take into consideration that we have collected this information for XYZ purposes, and that is what it is being utilized for, and you consent that you have given your data out of free will for purposes listed out as A, B, C, D, E, F, G, H, whatever may be the case. So that completely needs to be taken into consideration. What is also important to understand that the consent has to be expressed, the consent has to be in writing, it has to be absolutely clear. Correct? All of these consents have to be absolutely clear. Now, a lot of you, when the answer came as to, of course, that we are following the DPDP regime, kind of inspired by the provision or the aspect that, oh, we are a GDPR compliant company. Correct? So maybe there are things which we do comply with or which we don't comply with. However, we are taking into consideration GDPR meets DPDP compliance. That's not the case. The case is that GDPR is related to personal data. Correct? It relates to anything relatable to a person and includes offline data as well. That's not the case with DPDP. DPDP only concerns with regard to digital data personal protection. So what a lot of people or what a lot of companies have now started doing is started collecting information without storing it in the systems in a file manner, in a bound manner. Let's say, for example, the NDAs, the certain confidentiality objectives, certain IPR related objectives. So what they started doing, taking out in writing or in print and stating and collecting and storing them rather than doing them electronically. Now, you would go back to GDPR and you would note that GDPR has certain, in my second point, which I'm raising now, it has certain beneficial or certain relaxations. Correct? For example, in case you are taking employee information or taking employee information for an interview, there are certain variances or certain relaxations that are given under GDPR. And certain information, there is a technicality with regard to what the information basically relates to, and then it's divided into the classification as to what can be the harm. So certain things relating to race, ethnicity, political opinions are kept at the top of it. Correct. Second, or very important aspect becomes the personal information. DPDP does not make those differentiations. It states any or all of the information. So that can be any information which may also be in relation to your social media accounts. It can be also any information which may be in relation to, any past or previous performances. Everything has to be, kept in a manner. If it's electronically stored, it has to be kept, secure. Now, in GDPR, there is a direct implication on data processes. Who are data processes? Data processes are those who process the data where it might be given. For example, let me take an example. In case of a payroll case, correct? So the payroll is being done by, let's say, a third party of a company. So that happens to be a data processor. So GDPR places an obligation on data processes also, subjecting them to non-compliance. That's not the case in DPDP. DPDP places an express and overwhelming liability on the data fiduciary. Who's the data fiduciary? The data fiduciary, saying that it can fall on data processes. Data fiduciaries are the ones who are the rightful owners of it. Let's say the company itself, which gives the information to the third party. So any or all error or leak that may occur or anything which may happen with regard to employment data let's say, for example, in payroll, the data processor cannot be held liable. The fiduciary will be held liable. Correct? So these are some of the important aspects which you need to, kind of look into. Now, what are the essential principles that you need to follow as to collection of data, of employment data? The principles of lawfulness or legitimacy. Why do we collect information from employees? We collect them for tax processing, salary processing, social security, benefits, etc. Now, why would we want them to, which companies have now started doing without informing in certain cases, is to track down certain, which was laid down by Nimisha in a previous aspect also, to track down as to what they write on the social media also. Correct? So sometimes the company says we want access to that also as to what you're writing on the social media. Maybe not a direct, but an indirect access to it. But that's something to do with their personal life, and that has nothing to do with their employment. So what you're taking, why you're taking is very important. A lot of companies have these policies of asking for, where there are dating controls, where there is control with regard to whom you might be in a relationship with, or you might be seeing someone. And they ask all of this data to be processed. No, what is the legal legitimacy of this? There is no legal legitimacy. So companies now have to think of what all data they actually need to process. Correct? For example, a lot of them have this data or this policy as to how many times have you traveled abroad in the past 6 months? How many times have you traveled to X country, Y country, Z country? And they almost follow a standard process and a procedure where these questions have been kind of forthwith provided to them by their, by the parent company abroad, and they just follow it blindly. So the Indian entities, the IT companies, the HRs and the tech HRs no need to look into it as to what purpose this is solving, and only include such questions and such information which is necessary. There can be no discrimination in obtaining data. Correct? Now, if you're obtaining data or processing data, you want somebody's PAN, TAN, blood group, you cannot say I only want it for a particular group and let the senior side or some other side be bereft of it. So there can be no discrimination obtaining data. As I said, consent has to be absolute. Why you're obtaining, what is the purpose, how long will you retain that data? You all need to put that down in your policies and the employment contracts now. And the proportionality has to be with regard to data minimization, which I explained rather in the first point with regard to lawfulness and legitimacy, that it has to be data minimization. What does that mean? That in case your company is just providing the standard provisions with regard to EPF, salary processing, you just need the person's PAN, address. Correct? Rest on. Any question there? No. Why would you require all of the other data? So what do we need to do with regard to employment agreements? We need to set out lawful collection and notice requirements. The consent obligations have to be clearly explained. The retention requirements, why you're retaining the data, also needs to be completely explained. There has to be security of employee data. So that's very important. You kind of need to tell how you're going to store that data, what you need to store that data for, what are the processes and the processes that you're using to store the employee data. And of course, a privacy policy. Correct? Your privacy policies need to be revised and you need to maintain a privacy policy. I think I'll just fall short of time with regard to if I go through the whole presentation. So I will just take a couple of minutes more to kind of, summarize what I just want to point out. See, the idea behind all of this, of the policy which I was explaining with regard to employment employee data, is to understand and to tell the employee that he has the right and he's in control of his own data in an entity. Correct? Whenever an employee wants or whenever an employee requests, that data needs to be deleted also. Correct? But does that make you as an employer liable to the whims and fancies of an employee? That's not the case. So there may be certain data which the employers or which the company may ask for, and if an employee refuses, you may have the right to kind of tell them that we will not be moving forth, or we will not be, taking your employment. That is not a floutation of the Data Protection Act. That's a floutation of the terms and conditions of an agreement. For example, if you need somebody's consent to tell them whether they will be stationed at a particular place, whether they are okay with that, and he says he refuses to give that, which gives you a kind of a backlog to state that, how am I to process, how am I to understand whether he wants to join or not. You can deny it. And he can't go under the DPDP Act claiming that since I refuse to provide information, I have been now held to be liable. That's not the case. So intelligible differentia also needs to be taken into part. Just to say, to stir up the pot, I think that's quite enough for today to, kind of think about data protection and employment rights and employees and the companies. And with that, I come to the end of my presentation and my speaking part. Happy to entertain any questions if they come up right now, or in the comment box, I'll leave my email address. Over to you.
That was a great speech, Rohitash. Thank you for it. And I guess you already have a lot of praises in the chat box that are unchecked. I would like to request you to just share your email ID in the chat box, since we have a time constraint. Our audience can reach you out directly for any queries. Sure. Thank you for the amazing and wonderful speech. Now, moving ahead, I would like to invite Ms. Swastika Goswami to share her insights with all of us.
Thank you so much, SK Associates, for inviting all of us to this forum. Because I missed the first few minutes of the introduction, I would quickly, in a minute, try to introduce myself. I am a corporate lawyer. I have more than a decade of experience, and currently I am working with Rimini Street as a corporate counsel for labor and employment law for APAC, and I am looking into 9 countries of APAC, including India. As you know, this session is for employment law essential for entrepreneurs. I will try to talk about the 10 labor and employment law takeaways for entrepreneurs, specifically for startup founders. So, however, my co-panelist, both Nimisha and Rohitash, has made my work really easy, because they have covered 3 or 4 points out of the 10 key points that I'm going to talk about. So from a very startup founders perspective, if we look into the labor and employment law, what are the very essential things? How do they start when they start hiring employees? So my focus will be on that. So I think once the founders agreements are in place, and now we need people to make the project work, or make the idea of the business work, the first thing we need is agreements. So we really need smart written agreements. So as Nimisha has said, it is the founders agreement. Once you have an employee, it can be the employment agreement or the IP rights, confidentiality, termination terms, which are very well defined. So the first step, as soon as our idea of the business is live, it should be the written agreement. So I would say that usually when founders comes together and they start hiring, it is more on a fiduciary basis or trust basis that we start onboarding people. And therefore, we don't really pay much attention. The founders really don't pay much attention to the employment-related agreements, because most of the people you hire are your known or whom you really rely on. Let it be the co-founder or the other, probably the account person, HR person, or IT person. So I think the first, every founder should be very careful about, and should not think twice before paying to the lawyer in terms of drafting employment related questions. There are always formats available on the internet, but I would suggest that it's always good to have a lawyer and review it rather than just going by the available format. So going to the next point is, how do you classify your workers? Once you have a business, you need to really understand whether you want to have full-time employees or independent contractors or third-party contractors. Again, when we say contractors, they can be consultant, freelancers, fixed-term contractors. How do you want to hire them? Because all of this will have tax issues and other benefits that you give to the resources will come into picture. So it has a direct financial implication too. So you really need to be very careful about how do you want to hire people, and you really have to, the founders really have to be careful in terms of understanding the different categories of employees or resources that they can hire. Third will be the minimum wage or the working hours related obligations. Now, when we start a company, at times it is in a particular state of India, or it is cross border, having a branch in some other country, and all the jurisdiction, every place has their own minimum wage related standards, compliances, and also the difference in working hours. In few countries, even the weekends are not Saturday, Sunday. It differs. So keeping all that geographical or jurisdictional compliances in mind, it's very important that you make your documents or agreements very explicit about the minimum wage, overtime, working hour laws. If there's a overtime or shift, then are you paying for those overtime or the shift allowances? Also, if there are interns, suppose, then nowadays it's very much suggestible not to have any unpaid internships unless it is clearly permitted by the law of that particular land. So I think this is the third point, that having a clarity on in terms of the wage or the salary and the working hours. Next, I would say, will be protecting your own intellectual property. Irrespective of the fact whether idea of a business really wins or loses, whether the business really makes an impact or not, but the idea itself or the invention or the trade secret should be protected. And in order to do that, you need to have very strong IP agreements, or you need to make your employees or anybody third party who will have access to those, you should, IP assignments, you should get them signed a confidentiality agreement or IP agreements, so that if you make it a very big business, then of course you definitely need it. But also, if you fall, your idea is protected. Idea, trade secret, codes, branding, whatever you call it, everything you should put it under the bracket of IP and try to protect it explicitly by making required documentation or agreements. Once you have people onboarded to the company, it's very important that you make a very inclusive workplace. In order to do inclusive workplace, as my previous speaker has already said, you need to make policies or documentation, maybe code of conduct, which makes it very clear that there is no discrimination on the basis of gender, race, religion, age, disability. In fact, disability is something you need to give more focus on, so that people know that you are eager to take people with some, specially able people too. So you need to make documentation or policies in regards to those which makes your organization, which makes it explicit that your organization follow non-discrimination laws. Uh, as I previously spoke about the wage and working hours, similarly the leave and benefit requirements, let it be paid leave, sick leave, parental leave, or statutory benefits like in India, suppose PF or gratuity, it changes as per the jurisdiction. It's very similar to how we say minimum wage or working hours. It at times changes from state to state when it is within India, and even when it is somebody working from outside India, it changes vastly. So in both the cases, it is very important that we seek legal advice from local lawyers. If it is of other country, then probably that country's lawyer or law firm will reach out to them, understand the leave and benefits requirements, and make policies accordingly, make documents accordingly. Next is maintain a safe workplace, as Nimisha has told about the POSH or other policies that organizations should make. So making a healthy work environment is on the employer. Definitely, once someone joins a business or a company as an employee, it's on them too. But setting the tone at the top, as we say, is very important. How a company sets their culture depends a lot on the leadership. So it's very important that you make those policies, and not only just make it for the checkbox purpose, but actually follow it day in and day out, and follow it in practice, and make it very evident, obvious for everyone around the leadership that there is no other way but to follow the safety related workplace policies. In today's time, there's another important thing is termination protocols, because nowadays organizations need to, or at times reaches a point that you don't have any option but to terminate. But you also have to understand that citizens or employees are also very aware about their rights now, which is very much needed, and it puts the company it makes a lot of litigation comes to the company, because you terminate and then you did not follow the protocol, and somebody writes to the labor officer, and your company is flooded with labor court issues. So in order to avoid that, it's very important to have a termination protocol, whether it is for PIP, for misconduct, layoff due to a business contingency, or probably a position elimination or redundancy. But all the scenarios should be very clearly stated. If it is a PIP, then performance improvement plan, then what is the maximum time you will give, and will it be that immediately after a PIP failure you will terminate? If it is a position elimination, then what you will give as a severance? Or if it is a layoff, then what are the benefits you will give? This thing should be very clearly stated. Previously, most of the organization used to keep it, very, I would say, diplomatically, silently. They used to talk about it, but very diplomatically. But now, I personally think that we need to be very clear on our stand as a company, what we will do, what you will get, and actually this should be there in the policies, so that when a scenario comes and company takes an action, the company is not in a legal battle again. Okay, going to the next is something already Rohitash has covered. It's being transparent with employee data, how you can really protect the employee data collected. As we say, the use to the on need basis only, deletion of the data if not needed, and all the points that already my previous speaker has covered is an important aspect, because nowadays data privacy or the how you deal with the data plays a very, very integral part in terms of your employment laws. Last but not the least, it's a generic one, but in my personal opinion, everything needs to be documented, and in today's time and era it should be digitally documented, so that you can access it anytime, anywhere, whenever needed, on a need basis. So let it be at times what I often see is if there's a employee was probably terminated after a year also, there can be an issue where that particular records related to the termination comes into picture. So in my personal opinion, documenting everything properly, let it be the employment decision, complaints, performance review, HR policies, or maybe the audit reports and everything, if it is an internal audit report but not really a statutory audit report. If your company doesn't need to do a statutory audit as per the compliances because you have not reached a particular revenue, but you do an audit on your own internally, then even those reports or the gaps that were found needs to be really documented and kept safely. So I think that having everything well documented is very important. What I usually see when I talk to any new founder is that because until you reach a particular revenue level, you are not very eager to have a lawyer of your own or a law firm tie-up, because that looks very expensive for that period. But probably, they say the more you sweat when you are in peace, the less you will bleed when you are at war. So probably it's that if you pay some amount to a lawyer when you are starting, you will probably not have to face the consequences of a litigation when there actually can be gaps. So I would conclude by saying that as startup founders, anybody should follow this 10 key guidelines and look into the legal aspect accordingly. Thank you.
So firstly, thank you, Swastika, for taking your wonderful time and giving such an insightful speech to all of us. And yeah, as you said, we do all face the very same problem. And gig workforce hiring has become quite difficult nowadays because everyone is trying to do a diploma in law by Googling out. And obviously, they are very well aware of the rights. That's right. Thank you for your information. Please do share your email ID in the chat box. But if anyone has any queries, they can directly reach out to you.
Thank you.
A pleasure having you on the panel. Now, moving ahead for today, I would like to invite, last but not the least, Ms. Maria Kedaka from Zambia to share her insights with all of us.
Hey everyone, greetings from Zambia. Hope you're doing well. Zambia is quite warm. We are transitioning towards winter. So I hope you're all doing great. Thank you, SK, for this opportunity. I've really learned a lot, despite being a lawyer and, in this profession, I still have learned a lot. I've learned that we learn every day. But the good thing about being a last speaker, rather, is that everybody has said whatever that you prepared. Like Swastika has just said everything that I wanted to say. But anyhow, I would tailor my discussion to if you are an investor and you would love to come and invest in Zambia. So I will border my discussion towards Africa and some countries within Africa, Zambia to be precise, and just the general aspect. Firstly, I would say these conversations are very timely because Africa has been hit by high rate of unemployment levels. So we've seen a surge into entrepreneurship. We've seen a surge of people starting up businesses, incorporating companies. So these discussions are very, very meaningful, as they are very enlightening. So I will also, I'll call mine a checklist, since basically almost everything I wanted to say has been said. So I'll just kind of summarize it, and I will call it a checklist. If you want to come and invest in Zambia, this is a checklist that you need to bear in mind. Firstly, like many other jurisdiction, there are many laws that govern labor laws. According to different jurisdictions, that vary a number of laws that govern. But in Zambia, we have what we call the Constitution. The Constitution governs labor laws. We have what we call the Employment Act. This is an act that actually also governs labor laws. We have also what we call a minimum wage and conditions of employment law. We've also got what we call a national pension scheme. And lastly, we have what we call the Industrial Labor and Relations Act. So basically, these laws and statutory instruments are just there to govern the laws, the labor laws in Zambia. Now, so here is a checklist. If you want to start up a business, it will be broad, then I'll narrow it to the Zambian perspective. So if you want to, want to be an employer, so this is your checkup list for startups. Firstly, it's employment contract. Everybody, almost all the speakers have spoken about why it is very, very important to have an employment contract. In Zambia, according to our laws, you can only draft an employment contract if that employment is for more than 6 months. So these conditions vary according to jurisdiction. So it's very important to go back to your jurisdiction, to go back to your laws and check when you're drafting this employment contract, what is the law saying in your country? So yeah, like I said, these might include job titles, salaries, hours of work, leave entitlements, and termination conditions. Now, a very good question would come up. You draft your contract agreement, and you have your conditions in that particular contract, and there is an Employment Act. Sorry for that, just a sec.
Sure. Until Ms. Dhaka returns, I would like to again request all participants to kindly switch on their webcams.
Sorry for that distraction. So what a question comes, if you are drafting your employment contract and there is the labor laws, so which one precedes the other? Which one is more important? So it is just very important, as you tailor your conditions of employment, tailor them in line with your laws, the employment laws in your jurisdiction or in your country. There is also an aspect of minimum wage, which has been spoken about. It's very important to have a minimum wage. Like in Zambia, the government have stipulated minimum wage for various kinds of employers. We had seen a surge of investors, which were Chinese, and we saw that they were giving low salaries beyond the minimum wage. So Zambia and the government has stiffened the labor laws and ensured stiff punishment for offenders that actually do not what's the word? Offenders that do not comply with these labor laws. So these laws, this minimum wage differs according to the job that you're doing. So we have domestic workers covered, we have workers working in industries covered. So basically, as long as you're working for more than 6 months, you are covered in the law of Zambia. Then we have working hours. Our working hours also differs according to jurisdiction. In Zambia, you do not have to work for more than 8 hours. 8 hours is the maximum amount of work one has to do in a day, and 24 hours per week. And if you're going to give your employee extra work, of course, you need to give them what we call overtime. Then there are leave entitlements. Leave is very paramount. So we have what we call annual leaves. Every year, every month, an employee is entitled to 2 days off. And it actually depends. For a woman, we've also got we've also got, because of our biological makeup, we've got what we call Mother's Day. So every month, a woman in Zambia is entitled to what we call Mother's Day, in which they do not have to go for work. Then we have also got sick leave. When you're unwell, you can apply for sick leave. But however, this one is subject to medical verification. We've got also what we call maternity leave. If you are a woman and you are expecting, you're about to see, if you're about to have a baby, about to conceive, you are entitled to what we call 14 days. Potential extension, you are entitled actually 3 months leave and 14 days potential extension. And this is not only for the women. Even men are entitled to paternity leave. So 14 days after the birth of a child, a man is expected to go on leave. So these conditions differ according to, like I mentioned earlier, jurisdiction. We've also got public holidays. As a worker in Zambia, you do not have to work on a public holiday. And if you have to work on these national holidays, public holidays, you are compensated at work. So I'm also going to talk about social security contributions. In Zambia, all employees are supposed to be registered with what we call it a national pensions security scheme. This is where every month a worker is expected to contribute, towards their benefit. And this percentage is at 10%. So 5% is split between your employee and 5% is coming from from your employer. So we always have what we call a social security contribution, where every employee is supposed to contribute, for their benefits. Then we've also got what we call Workers' Compensation Fund. This one it compensates for injuries during the course of work. So if your employee injures themselves during the course of duty, we have laws that actually ensure that you are supposed to, compensate for these injuries. We have healthy and safety. Zambia is major export, is highly rich in mineral resources. So our economy basically depends on mine. So we have a lot of mining, companies, and these are mostly handed over by investors. So foreigners that come in and invest into our country. But they had seen a stage of lack of security in these workplaces. So what the government did was it came up with what we call a Working Condition Occupation Health and Safety Act. So if you're an employer, if you are a startup, you need to ensure that the safety and health of your employees is a priority. So safety gears, everything that a startup in Zambia should bear in mind. So also there's also what we call employee representation. as an employee in Zambia, you have a right to join trade unions. So you have a right to collective bargaining, of which your employer should adhere to. So this differs, like I said, according to jurisdiction. So also, there's also what we call this has already been spoken about. There's also what we call the recruitment compliancy. This is where recruitment is non-biased, it's non-discriminatory based on gender, race, disability, and religion. And it's also very important to mention that even as a foreigner, you can work in Zambia so long you have what we call a work permit, which is granted by the Department of Immigration. So this is all I had to say in summary, because I mean, everybody has spoken and it was a very healthy, informative conference. So this is the last thing that I would have to say. This is a tip for startups. So when you are navigating as a business owner, as somebody that runs a business also, and was in a phase of, starting up a business, there's certain lessons that I've learned. So it's very, very important as you start your startup businesses or you incorporate a company to consider legal advice, so that your employment framework ensures that you comply with the rules, the regulations, the policies in that particular country to avoid penalties. So thank you very much. This is all I had from you. Thank you so much.
Sure. Thank you, Maria, for participating and giving us such wonderful insights, especially having someone from South Africa elaborate on this topic was a special vertical of this conference, because we have no other representatives from South Africa yet, I guess, in this conference except for you. I would like to request you to just share your email ID in the chat box so that if anyone has any queries, they can directly reach out to you. Sure. Now, moving ahead, I would like to thank all the speakers for today for your wonderful presence and obviously your time that you have contributed to this conference to empower our young entrepreneurs sitting out here. And I would also like to thank all our participants for joining us and hope that each one of you has gained some knowledge from this conference. Looking ahead, we are excited to announce that our upcoming conference will be held in June from 15 to 17 on global risk management and compliances, wherein 16 FRM professionals shall be participating in from 30 plus countries. And we hope to see you all there and engage in more insightful discussion. So thank you all again, and we look forward to reconnecting with you at our upcoming conference in June. We do request you to subscribe to our YouTube channel and follow us on all social media handles to stay connected with us. The recordings of this conference will be uploaded in 24 hours from now on our YouTube channel. You may all view it and drop your valuable feedback in the comments section. Participants, you shall be getting certified via your form, which will be circulated in your group in 5 minutes from now. I request you all to fill it, whereas speakers, you shall be getting your certificates by tomorrow. Thank you, everyone, and farewell for now. Have a great day. Take care.
Thank you. Thank you, everyone.
Thank you, everyone.
Alliance team members and BD team members, I request you to kindly attend your team meetings tonight. Have a good day, everyone.